other distinguished guests on the dais, ladies and gentlemen. We have gathered today to remember an eminent legal luminary, and the object is not only to remember him but to tell something about our personal experiences, about his caliber, about his manliness, about his behavior, which the present generation of legal fraternity and other members of the civil society do not know. Sri Das, having passed his BA Honours and LLB degree from Law College, practiced in a district court because in those days the High Court permanent bench was not here. He taught himself to earn money by becoming a pleader, and after 3 years he became an advocate. I first knew about him from newspaper when I was a student, when he was defending the accused persons in sensational Santi murder case, Santilata Hatya Mokaddama. Then when I joined the law college, I knew him as my lecturer. He taught us 2 subjects, law of torts and law of international law. In law of torts, he taught us, I still remember the famous English case of Ashby versus White, and distinguished and explained the difference between damnum sine injuria and injuria sine damnum. Those words still reverberate in my mind. In law of international law, he started his lecture by telling that my knowledge of international law is same as that of yours. With this prelude, he gave us an entire narration as to how international law is important in the context of the devastating effect of use of atomic bomb in Japan during the Second World War. And unless the international law develops, then the entire world will perish. He gave us an idea about the international organizations like WHO and UNO. He gave us an idea how there is no codified international law, so it depends upon agreement between the parties and how it should work. What he told us in 1960 really later on developed in the true spirit of international law. So that was his astute statesmanship. When I joined the bar in 1962, by that time he had already become an eminent criminal lawyer, but I had several interactions with him. I will narrate 1 or 2 instances only. In one of the case, as a junior lawyer, he had engaged Mochala Sitaramaya from Barampur. So on the day of argument, on the day of first start, the Sitaramaya came, and in the previous evening in the conference he asked, "Have you tapped the IO?" Madhabananda said no. Then, "Have you contacted the doctor?" He said no. And then I won't conduct this case. He left, and Madhabananda was left to continue it. So that was it. In a humorous way, he was narrating it. There are 2 types of cross-examiner in criminal case. One was like Mr. Chintamani Acharya and Subbarao, who used to be very aggressive and try to elicit from the witness what they want. But Madhabananda was of a different type, like the Mr. Dinabandhu Sahu, who will try to take the witness with him and then try to elicit what he wants. And he has always been successful. As a criminal lawyer, he was well known. As a government pleader, which was then considered to be a very prestigious appointment, he continued for a long time. But he didn't keep his practice restricted to the district court. He came to the High Court also. 2 instances I will narrate in the High Court. He was appearing for it. There was dispute between two sects of Mahimada, Kalpaladhari and Kaupinidhari. And I was a junior to Mr. B.K. Pal, and we were for the appellant, and Madhabananda was for the respondent. And Bimal Babu thought we have a very good case. So we argued before the learned judge. Then Madhabananda Das did not touch on the question of law. He only narrated very succinctly how these disputes between two sects religion, what are the real differences, why such dispute has come, and ultimately summed up that this dispute is a only frivolous litigation, and ultimately he won. So that was his tact. He was a very tactful lawyer. Another instance was he was arguing an election case before G.K. Misra. When he found that the learned judge is not agreeing with, and probably he found that he is probably for some adamant reason he is not agreeing, then he himself withdrew from the case. So G.K. Misra issued a notice of contempt. Even then he did not appear. So out of anger, G.K. Misra passed an ex parte decree. But the ex parte decree was set aside by the Supreme Court in the first hearing itself. The matter was remitted back, it came before some other judge. Madhabananda again appeared and he won that case. So that is why I say he was a very tactful lawyer. And there are many such instances. He was a very, not only a tactful lawyer, he was a very, very good host. In each of his son's marriage I have attended, he will take personal care to see that the guests are well fed. That was his character. I have a habit of visiting the Vinodbihari market for vegetables, and Madhabananda, if it is Saturday, you will definitely find him on a cycle rickshaw, and rickshaw full of vegetable and fish. He will be there. And so today we do not find such caliber amongst the legal fraternity, but if the present fraternity would emulate some of his mannerism, behavior and conduct, they will certainly be successful in life. I offer my respectful homage to my teacher, to my colleague at the bar, and to an eminent legal luminary of the state. I pray that his soul rest in peace. I thank the organizer for having organized such an event, which I believe that it is the obligation of the society to hold such functions in memory of such eminent person, not by a committee or of the family member to do that. But unfortunately today we do not have any civil society, and I have only something to commend. See, when you hold a meeting and give particular time to every speaker, the speaker should restrict himself to that time, because by this time meeting would have been over, and I am sure though 10 minutes was given to me, I have concluded much more before that. Thank you very much.